Bismillah ar-Rahman ar-Rahim. Wassalatu wassalam ala ashraf al-mursaleen. In this lecture, we are going to proceed in commercial law for business students or Al Isra University students. We are on page 174. We are going to talk about transferability of shares of a company, of course. When a member ceases to belong to the company, this does not affect the existence of the business as a whole, although it might destroy a partnership. The member's interest in the business can be transferred or by sale or other means to a new member. In a public company, such rights of transfer are unaffected, and a sale of shares may take place under the auspices of the stock exchange. Separate property rights. The assets of a business become its own property on incorporation. This is advantageous in a manner of ways. For example, a member who leaves cannot excuse me. A member who leaves cannot disturb the business by claiming any particular asset or as his own or her own. He or she is entitled to recover only his or her financial stock at its current value. Similarly, if the company goes into liquidation, members cannot be personally bankrupt when the company's assets are exhausted before all its debts are satisfied. All they will lose is their financial stake in the business. Raising capital. Unincorporated businesses are very restricted as regards obtaining new capital. The only options are to increase the number of members or obtain a bank loan. Recruiting new members while increasing capital results in business profits being spread more widely and perhaps more thinly. Bank loans involve large interest payments and usually are unobtainable without the security of a mortgage on the member's own house or homes. A company may be able to borrow money secured by a charge on its own assets. A public company may advertise public to attract loans through an issue of debentures. This advantage is likely to be enjoyed only by a company with large enough assets to secure the loan. The members of very small private companies, quasi-partnerships, are usually required personally to secure the debt by mortgages on their homes. Continuity. Once registered, the company's existence continues regardless of any changes in membership. Only winding up proceedings can bring the company to an end. Okay, we are going right now to proceed with section number 2, page 177, and talk about types of corporations. Types of corporations. The partnership. This is a type of unincorporated association, which simply means that it is unorganized without any legal personality distinct from its members. There are many different kinds of unincorporated associations which exist for social, educational, political, and business purposes. Any person may belong to one that includes sports clubs, social groups, trade unions, and political parties. What distinguishes a partnership from those organizations is the motivation of the partners, in which they have joined together intending to carry on a business with a view of making sharing profits. The partnership is the favored method of business organizations for any professionals like doctors, solicitors, and accountants. They can share facilities with a sole practitioner would be unable to afford. It is also very common for small businesses to operate from this base, as it enables startup capital and expertise to be drawn from a number of people. Partners, like sole traders, often raise their contributions through a bank loan and are also personally liable for business debts. The partnership is governed by the law, their creation, and regulation. Forming a partnership. It is usual to formalize the existence of the partnership by written agreement, which is sometimes described as the partnership deed. Writing is not essential, though. The partnership relationship may be implied from the conduct of two or more persons carrying on a business in common as joint proprietors with the intention of making and sharing the profits arising from their enterprise. The partnership relationship, with all its ensuing rights and duties, exists from the time when the business is up and running. Planning to run a business does not in itself create the partnership. For clarity and for eventual purposes, it is wise to have a written partnership agreement which indicates the nature and purpose of the business in name and addresses, its name and address, the amount of capital invested by each partner or owner, and how profits are to be shared and paid. If there are sleeping partners whose only involvement is providing capital and taking a share of the profits, the agreement should specify which partners are actually responsible for the management. The partnership agreement, whether written or unwritten, is a contract governed by the rules which you have studied earlier in this book. Numbers of partners. There must be at least two partners to an and no maximum number of partners. It was believed that a business of such size should more appropriately be run as a registered company. All partners shall share the profits and losses. Hence, if it is agreed to deprive any partner of profits or to exempt him from losses, such condition shall be null and void. However, a partner who contributes only his works may, by agreement with others, of course, be exempted from sharing losses, provided that no remuneration shall have been allotted to him for his work. If a company's contract hasn't specified a partner's share in the profits or losses, such share shall be in proportion to his share in the capital. If the contract only specifies a partner's share and the profits, his share is the losses shall be equal thereto. The same rule shall apply if the contract only specifies a partner's share and the losses. If a partner's contribution is limited to his works and the contract has not specified his share in the profits or losses, such partner shall have the right to request this his works be evaluated, and such evaluation, shall be the basis for determining his share in the profits or losses in accordance with the above general rules. If there are more than one partner rendering works and their individual shares are not evaluated, such shares shall be considered equal unless proven otherwise. But if a partner has contributed in addition to his work a contribution in cash or in kind, he shall have a share in the profits or losses for his work contribution and another share for his contribution in cash or in kind.